generational land of the Huron-Wendat, the Seneca, and most recently the Mississaugas of the Credit River. Today, this meeting place is still the home to many Indigenous people from across Turtle Island, and we are grateful to have the opportunity to work on this land. So today we're studying liberalism. Liberalism grew out of a struggle between Parliament and the Stuart Kings of England in the 17th century. And that struggle culminated in the Glorious Revolution of 1688. And at the level of political power, the Glorious Revolution established the supremacy of Parliament over the monarchy. So the Parliament was supreme over the monarchy. And at the level of ideas, the revolution established that public authority, the right to rule, is not derived directly from God, which is what people had believed until then, that God devolved authority to the monarchy, and that's why the monarchs had the authority to rule over England. But instead, sovereignty resides in the people themselves. So the people themselves have the power to self-govern, and then they devolve it or they delegate it to a sovereign. So this simple idea had revolutionary implications. And one of the revolutionary implications was that the authority to rule is a trust that can be removed. So the people can delegate authority to a sovereign, and they can remove that authority from the sovereign. Another revolutionary implication is that the sovereign must rule within the law of the land, and the law of the land is made up by Parliament and interpreted by the courts. So now, for the first time in history, the rule of law applies not only to the people, but also to the sovereign, the leader of the people. These ideas were expressed in the American Declaration of Independence. We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain inalienable rights, that among these are life, liberty, and the pursuit of happiness, that to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed, that wherever any form of government becomes destructive of these ends, it is the right of the people to alter or abolish it and to institute new government. And then these ideas were repeated again in the Declaration of the Rights of Man and the Citizen during the French Revolution in 1789. So the Declaration of the Rights of Man and the Citizen says, the end of all political associations is the preservation of the natural and imprescriptible rights of man. And these rights are liberty, property, security, and resistance of oppression. The nation is essentially the source of all sovereignty, so by the nation they meant the people, nor can any individual nor any body of men be entitled to any authority that is not expressly derived from it. So the four principles of classical liberalism are all related to the broad concept of freedom. So the first is personal freedom. That refers to the absence of coercion in the various realms of life. So personal freedom includes free speech, freedom of religion, the right of private property, and the right of political opposition. The second freedom is limited government. The state is an instrument that serves a particular function in society, so it serves a particular role in society, and it doesn't have an expansive role. It's not able to govern everything that happens in society. The third commitment of classical liberalism is to equality of right. Everyone must abide by the same laws, and the state enforces those laws impartially. And then finally, consent of the governed. The government emanates from the people, government is responsible to the people, and government may be changed by the people. So what I'm going to do now is go through these four commitments of classical liberalism in a bit more detail. So personal freedom is the right to be left alone, essentially. The right to do what you want to do without interference. And the idea is that that freedom only runs out when the actions of one person inhibit the freedom of another person to do as he or she chooses, also without interference. So in the Declaration of the Rights of Man, it was written that political liberty consists in the power of doing whatever does not injure another. You can do whatever you want up until a time that you injure somebody else. The exercise of the natural rights of every man has no other limits than those which are necessary to secure to every other man the free exercise of the same rights, and these limits are determinable only by law. So liberty consists in the power of doing whatever does not injure another. And John Stuart Mill explained the value of this type of freedom in his book on liberty. The only purpose for which power can be rightfully exercised over any member of a civilized community against his will is to prevent harm to others. His own good, either physical or moral, is not sufficient warrant. So I want you to think about this. For example, I want you to consider whether there is a liberal justification for seatbelt laws. I feel like this is a really interesting way to think about whether or not seatbelt laws, or what is liberal and what is not liberal, and whether seatbelt laws are illiberal by definition. So sometimes these are called negative conceptions of freedom. And the reason for it is that it implies no positive obligation on the part of the state. So these freedoms only depend on the state not interfering. So they presume, or they infer, they imply that freedom is something that occurs naturally. We all have or exist in a natural state of freedom. Freedom simply exists. And it's the job of government not to interfere with this naturally occurring freedom. Individuals are born free, and the state has no right to interfere with their freedom. And specifically, as I said before, the specific rights that this protects are freedom of speech, freedom of religion, freedom of association, the right to own private property, and the right to political opposition. So these are the negative rights that I'm talking about. Classical liberals also see the role of government as very limited. So for classical liberals, the government has only two purposes: to protect the political community from external enemies, and to protect individuals within the community from harming each other. So in connection with the principle of freedom, the state steps in when people hit up against one another in the exercise of their freedom. The idea of rights, which is central to liberalism, is that rights protect people from each other. I have a right to protection from you or against you, but also that rights protect the people from the state that might overstep its mandate. So citizens have rights that cannot be violated. They cannot be violated by other citizens or by the government itself. One of the specific concerns that drove this conception of the scope of government, what government had control over, was religious freedom. So classical liberalism developed against the backdrop of hundreds of years of devastating religious wars in Europe. So before people started to think started to theorize liberalism, what preceded that moment in history was hundreds of years of religious wars in Europe. And those religious wars were motivated, liberal thinkers reasoned, by the connection between religion and state power. So religious wars was one of the problems that liberalism was meant to address. Liberalism as a theory of the scope of government and what government should be responsible for. So liberals argued that in particular, when a state adhered to a religion, say for example, if France was Catholic or if England was Protestant, then individual citizens of those states who practiced different religions would have to be considered traitors to the state. So if France is Catholic and there are Protestants in France, those Protestants are not just Protestants in France, they're actually traitors to the French state. And so the liberal solution to this problem was the secularization of state power, decoupling the state from official religion. So liberals insisted on a secular state, a government that would have no religious affiliation. And so religion was repositioned as a private matter, a matter of personal belief and practice, private belief and practice, a matter between a person and his or her God, and not the concern of the state. Free exercise of religion. So John Locke, for example, wrote in A Letter Concerning Toleration, "The care of souls cannot belong to the civil magistrate, because his power consists only in outside force. But true and saving religion consists in the inward persuasions of the mind, without which nothing can be acceptable to God." So it's a private matter between you and your God. And the state has to be tolerant, the liberal state has to be tolerant of all religions and even-handed in its treatment of religions. And, on the other hand, religions and religious leaders must in turn not meddle in politics. Equality of right is the third principle of classical liberalism. Everyone is equal under the law, and the law is blind with regard to differences of status and wealth. So taken in the context of the time, equality of right is actually a radically egalitarian principle in the sense that it offers a direct challenge to hereditary rights. Previous conceptions of law had always distinguished law by status. So in other words, different laws applied to different people depending on their birthright. So kings, princes, lords, and dukes, people of status, nobility, were normally above the law. And so the idea that justice is blind is a liberal idea that implies that the law applies equally to everyone, regardless of race, class, gender, and so forth. At the same time, it's important to realize that the idea of equality of right was a classical liberal principle that was limited to the sphere of law. It didn't imply economic equality. And the reason for this is that producing economic equality would require redistribution, and redistribution would be a violation of private property. So the logic was that economic equality can only be achieved by taking from the rich to give to the poor, and taking from the rich violates the rights of the rich to their property, and that's therefore a violation of freedom. So for classical liberals, where freedom hits up against equality, freedom trumps. The fourth principle of liberalism is consent of the governed. Classical liberalism lodges sovereignty in the people, and the authority and legitimacy of government depends on the consent and the affirmation of the people who are governed. The sovereign only maintains his authority so long as a majority of the people cede it to him. And as I said, this is a major transformation. The authority to govern no longer comes from above, from God. Now it comes from below, from those who are governed. At the same time, for classical liberalism, the principle of equality of right does not extend to equality of participation. So despite the fact that it locates sovereignty in the people, liberalism does not have a very expansive or democratic conception of who counts as the people. The people, who are those in whom sovereignty is vested, are only all men who own property. And so it's only gradually over time that liberalism basically gets democratized and the franchise is extended beyond male property owners to include other people. So basically over time becomes universal. All right, so against this backdrop, I want us to look at the relationship between liberalism and democracy and to think about the meaning of the term liberal democracy, which is a term we hear all the time. So democracy is about locating power in the people. It's a radical idea. And especially once the vote is extended beyond property owners and power is vested in people whose interests are different than the interests who have traditionally held power, the interests of the people who have traditionally held power, democracy could be genuinely revolutionary. So democracy is a radical idea. It moves power from God and the monarchy to the people. It's a radical and revolutionary idea. Liberalism is about limiting or setting limits on that power. A liberal democracy is a democracy in which the scope of things that can actually be decided by popular vote is limited by devices like constitutions and a Bill of Rights and the rule of law. So the purpose of a constitution is to limit what democratic majorities and elected leaders can do. Okay, the purpose of a constitution is to limit what democratic majorities and elected leaders can do, the scope of the decisions that they can make. And that is one of the reasons that constitutions, practically every constitution in the world, enshrine property rights. Is that one of the great fears of early liberal theorists, one of the great fears was that the vast horde of people without property, so most people were propertyless, those people who would be the majority would use their political strength, would use their vote to redistribute wealth. They would use their vote to take away the property of those who had it. And the possibility that a democratic majority could potentially violate someone's right to their own property was preempted, was eliminated by the creation of a constitution that becomes then the highest and most supreme authority in the land, and that enshrines the right to private property. So the Constitution, which always includes a right to private property, limits the ability of or the scope of what democratic majorities can vote on, and it includes the right to private property. There are other individual rights that are enshrined in constitutions that are also designed to protect the individual from the majority or from a government that represents the will of the majority. So that is to say that the government is formed by the people, it's given authority to govern by the people, and supposedly it enacts or carries out the wishes of the people. But liberalism limits the reach of the government by drawing a distinction between the public sphere and the private sphere. So the public sphere is the scope or space that is reasonably under the jurisdiction of the government. The democratically elected government can intervene only in the public sphere, and the private sphere is off limits. So democracy is about extending power to the people, a radical idea, and liberalism is about limiting the scope of that power, which is a more conservative idea. Another right that liberal constitutions generally enshrine is freedom of religion. And what that means is that individuals are free to practice their own religion and to worship their own God in the way their religion dictates. The right to religious freedom locates religion in the private sphere outside of the jurisdiction of government. So governments are not allowed to interfere with religious practices. They're not allowed to tell people that they cannot engage in some religious activity if that activity is part of their religious practice. So you're probably familiar with this principle. We call this principle the separation of church and state. And what that means is that secular and religious authority are separate. A sovereign that tries to dictate how we practice our religion is overstepping the proper bounds of his or her authority. And a church that tries to dictate law or influence politics or public policy is also overstepping the bounds of their authority. So I'm going to give you an example now of a case in which the United States Supreme Court made a decision that actually was wrong, a mistake from the perspective of liberalism. So there's an indigenous religion commonly practiced by many indigenous people in the United States and Canada, most prominently the Navajo, but also the Kiowa and the Comanche. And this religion uses peyote as part of its religious ceremonies. So peyote is a hallucinogenic drug that is illegal in the United States. But most states in the U.S. make an exception for religious practice. So peyote is illegal as a recreational drug, but you can use it for religious purposes. So that's the religious approach to dealing with the issue of practitioners of this religion using this drug for religious purposes. But the state of Oregon does not make this exception. Oregon laws made it illegal to use peyote for any purpose by anyone, so there was no religious exception in the state of Oregon. And so at some point there was a legal challenge to this state law, and the legal challenge went all the way to the Supreme Court. And the legal challenge was made on the basis of freedom of religion. The state of Oregon was violating religious freedom by preventing certain indigenous people from practicing their religion. That was the argument that was made on behalf of the religion, the religious practitioners. And the Supreme Court surprised everybody, really, by finding against the religious freedom argument. The Supreme Court argued that a religious exception should not be made to accommodate members of the Native American Church. So this is a legal decision that actually limited the scope of religion, limited the amount of exceptionalism that a religion can claim, and allowed the state to say that you're not allowed to exercise your religion in this particular way. You're not allowed to use peyote to exercise your religion. So from a liberal perspective, this decision was actually a mistake. So now I'm going to offer you a more contemporary example of liberalism at work in Canada. So in 2011, we had an immigration minister named Jason Kenney. And Jason Kenney banned anyone from taking the citizenship oath with their face covered. So any immigrant who had come to Canada, was trying to become a citizen, had to take the citizenship oath, and Jason Kenney said, you're not allowed to do that if you cover your face. And on the face of it, this might seem like a neutral law. If it was a neutral law, that would mean it would be permissible by law because it would affect everyone equally. Jason Kenney actually argued that nobody was allowed to cover their face during the citizenship oath. It's not just certain people who aren't allowed to do so. So it's a neutral law. It applies to everybody universally. But actually, the rule is not neutral because, of course, there are only certain people who would want to cover their faces during such a ceremony. And those people are a small minority of Muslim women, those who choose to cover. And then not only that, but it discriminates against those women on religious grounds. The Muslim women who wear a niqab do not do it for reasons of vanity or to protect themselves from germs or because it's a fashion statement. They do it because they believe that their religion calls on them to cover. So the rule that requires those women to show their faces while taking the oath of citizenship, that rule obliges them to choose between their religious duties and Canadian citizenship, right? Canada is imposing a law on them that interferes with the free exercise of their religion. So Canada actually did pass this law. It became a law in 2011. And if Canada were merely a democracy and not a constitutional democracy, not a liberal democracy, then the niqab ban would have stood. It would still be a law today. It would still be the law that a person cannot take the oath of citizenship with her face covered. And the reason it would still be a law is because the law was made by an elected representative. It was made by a member of parliament who was also the Minister of Immigration. He had been elected into office. So by democratic standards, laws he make are democratic. On top of that, the law was supported by a majority of Canadians. So most Canadians think that you should not be allowed to take the citizenship oath. You shouldn't be allowed to become a Canadian citizen if you insist on adhering to the religious prescription of covering your face. Most Canadians agree with the law, so you have a democratic majority that's in favor of this law. And, as I said, it was implemented by an elected representative of the people. So on purely democratic grounds, the law stands. And in fact, the law was in effect for more than 3 years. But eventually, someone who would be affected by the law went to court to challenge its constitutionality. So in September of 2015, her lawyers went to court and they argued that the niqab ban was unconstitutional, that such a ban was prohibited by the Canadian Constitution. They argued that the Canadian Charter of Rights and Freedoms guarantees both freedom of religion and freedom of expression. And a law banning the niqab anywhere would have been a violation of both religion and of religious expression. So here's what the Globe and Mail had to say about it in an op-ed. Freedom of religion and conscience are at the core of the Charter of Rights and Freedoms because they are at the heart of what it means to be Canadian. We don't ask people to give up their religion when they come to Canada. On the contrary, Canadian law protects their religious practices, which is why Canada has welcomed all sorts of faiths persecuted elsewhere. If you find the niqab objectionable or discriminatory, and many people, including many Muslims, feel that way, then you have the absolute right to hold that belief. You also have the right to express your belief and to speak out against the niqab or any other religious practice. Freedom of speech is a fundamental constitutional value. So you can object to it, and you can even express your objection. But no matter how much someone's religion bothers you, you don't get to stop them from practicing it. Not even the Prime Minister can do that, not in Canada. So to recap, what's happening here is that the Constitution and the Charter enshrine a set of individual rights and freedoms. A commitment to rights is a liberal commitment, a liberal principle, and that liberal commitment enshrines a particular set of rights that the majority cannot violate. So that's what I mean when I say that liberalism limits the scope of what can be decided democratically through majority rule. Even if a majority believes that all people should be required to expose their faces when they're taking the citizenship oath, even if most Canadians believe that to be true, that preference of most Canadians will not stand because it's unconstitutional. It violates individual rights, and particular, in this case, individual rights to freedom of religion, to practice your religion in the way that you see fit, in the way that your religion dictates. And those rights don't derive from democracy, they derive from liberalism. I'm just continuing the lecture from on liberalism with a very brief addendum. In which I wanted to talk about the relationship between classical conceptions of liberalism and the ideology we now think of as liberal. So classical liberalism is actually quite a conservative doctrine, with its ideas about the limited role of government and the supremacy of property rights, whereas now we use the term liberal to refer to someone or some policy that is more on the left of the political spectrum. I say left and I put up my right hand. Left of the political spectrum. So basically, the reformulation of liberalism began as a reform movement within the British Liberal Party at the end of the 19th century. And what did it turn on? In essence, it involved a reformulation of the meaning and capacity for freedom. So remember that I said that classical liberalism starts from a presumption that freedom is a pre-existing condition. It's the state of nature in the absence of government interference. So from the perspective of classical liberals, all that was needed to produce freedom is basically non-interference with man's naturally free state. So to produce freedom, the government just doesn't interfere with the sphere of freedom, which is what's naturally occurring. And reform liberals proposed instead that freedom was not the natural condition of human beings, and that instead freedom was something that had to be enabled or produced. So this is basically the argument that reform liberals were making. They were arguing that a poor man is not free, and a destitute man is as much a prisoner as a convict. In fact, a convict generally eats better. A man who can't afford a streetcar ticket, let alone real travel, who can exercise no real choice in matters of food, clothing, and shelter, who cannot follow the siren song of the TV commercials, who can scarcely afford bus fare to the library, let alone a proper education for himself or his children. Is such a man free in an affluent nation? So the argument here is that people have different degrees of freedom depending on their wealth. And reform liberals argued that if individual freedom is the highest good of liberalism, the highest principle of liberalism, then liberalism had to have a much more robust conception of freedom. That it wouldn't be enough for a liberal state to be what they called a night watchman state, only a state that offers non-coercion and non-interference and the protection of private property. The state, a properly liberal state, would have to get involved in the business of producing freedom by eliminating the shackles or the limits on freedom that are imposed by or exist because of poverty. So reform liberals accepted the idea that government had caretaking functions, but then they add to those functions the interventionist role of producing freedom as capacity, a human being's capacity to exercise their freedom or to exercise free choice. So they extend equality of right beyond the sphere of law alone. Remember I said that classical liberals believed in equality of right, but that equality only was in the sphere of justice, right? Equality before the law, justice is blind, that set of ideas. Reform liberals would say, no, we need to extend the idea of equality of right beyond law to include economic equalization through redistribution, or through the provision of services like public education that are aimed at equalization. So a reform liberal would not necessarily argue that everybody has to be completely equal, but people have to be wealthy enough that they can exercise freedom. Right? Not everybody doesn't have to have exactly the same amount of wealth, but everybody has to have the amount of wealth that they're going to need in order to be able to exercise free choice. So one of the ways of thinking about what happens here is to focus on this move to thinking about freedom as capacity, the capacity to make truly free choices. So the wealthy man has more freedom. The wealthy man has more capacity to make free choices than the poor man. And it's the job of the state to equalize that capacity, or to render it a closer approximation of equal without engaging in too much coercion. So for reform liberals, the state or the government has an obligation to equalize wealth for the purpose of equalizing freedom. As I said, it doesn't have to be completely equal, but it has to get the poor man to the point that he can exercise freedom. He doesn't have to have the exact same amount of money as the wealthy man, but he has to have enough to be able to exercise free choice. So in the classical conception of liberalism, there's a trade-off between freedom and equality. Generating equality means engaging in at least some redistribution, but engaging in any redistribution at all means that you're taking from those who have more to give to those who have less, and that constitutes a violation of the freedom and autonomy of those who have more. And as I said in the last lecture, where there's a tension between freedom and equality, where the two clash, for classical liberals, freedom is the higher good. So classical liberalism is ideologically closer to the Conservative Party in Canada or to the Republican Party in the United States. And modern liberals redefine freedom in such a way that the tension between freedom and equality essentially disappears. So now equality implies freedom. So contemporary liberals take a more robust view of freedom. They define it as a condition that doesn't simply naturally pre-exist. And therefore, the government should be in the business of producing freedom by intervening to create some substantial approximation of equality so that it's not only the rich who have access to freedom. And that also, the difference between classical liberalism and reform liberalism, also essentially defines the spectrum of contemporary political ideology that organizes politics, defines political cleavages in many contemporary liberal democracies. So that's the scope of the substantive philosophical differences that define the right-left cleavage. The party to the left has a stronger commitment. I did it again. It's your left. The party to the left has the strongest commitment to equality because it believes freedom cannot exist without equality, and the party to the right is more powerfully persuaded by the promise of freedom and individual autonomy. So at this point, some of you will be wondering about the connection between the ideology of liberalism and what we know as the Liberal Party of Canada. So the Liberal Party has historically represented or stood for actually both types of liberalism. So it was initially a classically liberal party with commitments to what it called responsible government, by which the Liberal Party meant representative government limited by individual rights, including the right to trade freely. So the three principles of the Liberal Party up until the 1940s or so were representative government, individual rights, and a free market. Very classical liberal conception of the role of government. And then starting around World War II, the Liberal Party entered a new phase of liberalism where it was concerned more centrally with social justice and progressive social policy. So a social safety net that was designed to produce greater substantive equality. So specifically, in the 1940s, we have Prime Minister Mackenzie King, who introduced a mother's allowance, which was a monthly payment for mothers, and an old age pension. In the 1960s, Prime Minister Pearson introduced the Canada Pension Plan and universal health care. And then, interestingly, under Prime Minister Trudeau, the Liberal Party introduced the Charter of Rights and Freedoms, which speaks to the other side of the liberal commitment, the commitment to individual rights. So if we look at the history of the Liberal Party over time, we can see how the party reflects the commitments of liberalism in different ways at different points in history. So the party is initially or originally a classically liberal party that prioritized freedom and rights over equality. And then after World War II, the party started to incorporate policies that prioritized equalization and building a social safety net. And those are policies that are identified with the commitments of reform liberalism to creating freedom for those people who don't have it by dint of being born wealthy. And if we look at the Canadian political spectrum today, the contemporary political spectrum, we can also see that the Conservative Party has a stronger commitment to the ideals of classical liberalism, and then parties like the Liberal Party and the NDP have a stronger commitment to the ideals of reform liberalism. Thank you very much. I wish to acknowledge